and out of my FBI. Testing, testing, testing. Greetings, 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 greetings. It is I, your king, King Clifford Jefferson, a Senator of Godfrey, the fifth caravan Jew, son of folk, will of Jerusalem, on the reincarnation of who we know here at the English Third Temple Church of England as King Edgar the Peaceful, which we know as Jesus Christ. I'm here with another marvelous lecture to bring clarity to concepts that people claim they understand, but apparently they don't. All right, so I got another focus point that I want to focus on today. I got an email yesterday from the last video I did, the Anglo-Saxon relation to the lords and men was originally founded upon mutual contract. I got an email yesterday from somebody by the name of Roman Samuel, and he stated in the email, he stated, my surname is Samuel. I seen your background, the X. I remember you, our king. The show, The Last Kingdom on Netflix helped me a lot. This is our land, right? Okay. Very important we understand what was said in that email. Now, here's another, not email, but chat. All right. All right. Find it. I think it's true in there.
I've spent an eternity waiting.
There was two emails here. Now I only see one. I don't know where it went to. But he said his name was Quetzalcoatl or something like that. All right. Let's see. But he sent me a YouTube to take a look at. All right. And the YouTube, the gentleman that was speaking on the YouTube was Rod Hayes. All right. If any of you know who Rod Hayes is, he's a gentleman who speaks about a bunch of topics, on which I don't think make sense at all. I do admit that I was a member of the AEO, Ancient Egyptian Order, with Dr. York, Malachi York. Peace be, peace to the brother. But I, nonetheless, I branched out from that group, as well as I've been a member of many other organizations and societies. But for the sake of truth and of facts, I had to leave and go on my own crusade, which led me to me establishing the Third Temple English Church of England for all those who understand what nationality and standing in law and uh, birthright. You know, if you understand these concepts, then they must not be looked at from an abstract standpoint. The majority of the platforms that you go to that speak upon these things speak upon them in an abstract platform. Okay, they in an abstract platform speaking abstract things, which makes no sense at all. Which means that everything they say are unconscionable in regards to the original unconscionable contract that were made with the parties, such as the grantor and the grantee. All right, because in this conversation, it's in regards to what we call land. You know what I'm saying? We know land is distinct by it being allodial land and that being feudal tenure. All right, once again, land being allodial and that which is feudal tenure. We know the three types of feudal tenure land is what we call fee simple, fee indeterminable, and life estates. Okay, only three. And we know allodial belongs to the crown. Okay, so any person out there making a claim that they have a certificate of allodial title to the said lands, that's a complete and total fabrication. Okay, total complete fabrication. So without further ado, let's just get into the topic. All right, the video to bring truth to all that's been told on YouTube. You know what I'm saying? So we can bring clarity once again to your concepts. Your perceptions are wrong. In lieu of you claiming to have a right to an inheritance from anybody that granted it to you. All right? No one can give you something that they don't have. Okay? No one can give you something that they didn't have the right to give you. All right? If they did, then that's by what we call prescription. All right? Prescription or an easement by prescription. We know prescription of sovereignty is by way of acquisition of sovereignty, which results from what we call right of discovery, which got its start from right of conquest. We all understand these terms. All right. So without further ado, I want to hold you guys long, brothers and sisters long, but we're going to go to the video and then we're going to go break it down. Okay. So let's get started. Let's just read the definition real quick. Everybody see that? Allodial title constitute ownership of real property. The fixtures and the buildings don't count if you don't own the land. So the first thing about allodial title is the ownership of the land. All right? The ownership of the land. That is independent of any superior landlord. That means you had it first, and nobody give it to you, and nobody had to sign nothing off to you. It was originally in your possession. Quiet title, quiet possession, quiet use. Allodial title is related to the concept of land held and allodium, or land ownership by occupancy and defense of the land. Okay? Most property ownership in common law, key word, common law jurisdiction, is fee simple. Now, it's fee simple. In the United States, the land is subject to eminent domain by federal, state, and local government and subject to imposition of taxes by state and or local governments, and there is thus no true allodial land. Did y'all hear that? Most property ownership in common law jurisdiction and fee is simple. All right? Fee is simple is not the land type of ownership of land that's acquired in England. All right? That's not this type. Their type of ownership in what we call land, real estate, etc. is intel. All right? Intel. United States is fee and simple. Fee and simple comes with liens, encumbrances, priority, and everything else that goes along with you being subject to imposition of taxes. All right. In the United States, the land is subject to eminent domain power by federal, state, and local governments, and subject to the imposition of taxes by state and or local governments. We know taxes is the state of what we call a debtor. You had a creditor, you're a debtor. And there is thus no true allodial land because the one who owns the land is the creditor. All right. Some states within the United States, notably Nevada and Texas, have provisions for considering land allodial under state law, and the term may be used in other circumstances. Land is held of the Crown in England and Wales and other jurisdictions in the Commonwealth. Some land in the Orkney and Shetland Islands, known as Uto land, is held in a manner akin to allodial land, and that these titles are not subject to the ultimate ownership of the Crown. Okay? Very important to understand that. All right. So we're making reference to land here in North America, a reference to the difference between it being fee and simple and allodial. Okay? Fee and simple and it being allodial. Allodial is free from any encumbrances. All right. Absolute ownership. All right. But we see in the United States, the highest form is fee and simple. So there's no absolute ownership. The only type of ownership you got or possession right is life estate, fee indeterminable, or what we call fee simple. All right. Which both are in violation of the original contract. Okay. Which we'll get to in a minute. All right. Crown land. So reading Crown land. Let's see Crown land. Because it said land owned in the United Kingdom is owned by the Crown. All right. So what is Crown land? We're going to go over these terms. Because apparently people who are claiming they own land allodial don't understand it. All right. Everybody pull that up. Crown land, spelled Crown land, also known as royal domain, is a territory area belonging to the monarch who personifies the crown. Personifies, incorporate, uh, uh, incarnate means the same. It is equivalent of a entail estate. It didn't say fee simple, it didn't say fee determinable, it didn't say life estate. It says an entail estate and passes with the monarch, the king, the crown, the English throne, being inseparable from it. So if you say you have a allodial title, then of course it has to be entail because it can never be separated from the original owner, which is the crown, i.e. the monarch. All right. Commonwealth Williams Crown land is considered public land and apart from the monarch property state. So public land is called federal land, i.e. public domain, i.e. the public trust. Everybody understand that? Okay. Allodial. Allodial is owned by the crown. So let's look at the crown. We know what crown land is entail, which cannot be separated from the monarch. Okay. The concept of the crown as a corporation show developed first in the Kingdom of England as a separation of the physical crown and property of the kingdom from the person and personal property of the minor. Okay? So it says it's a corporation so. A corporation so is a legal entity consisting of a single sole incorporated office occupied by a single sole natural person. This structure allows corporation, a religious corporation, of Commonwealth to pass without interruption from one office holder to the next, giving positions legal continuity with subsequent office holders having identical powers and possessions as their predecessors. A corporation so is one of two types, either corporation and the other being aggregate. Okay, same thing they say in Chisholm versus Georgia. New Jersey, Provincial Council. This is the government. Okay, not no tribe, not no group, clique, a government. All right, made up of electors. All right, it says New Jersey Provincial Council was the upper house of the New Jersey legislature under colonial rule. We know the colonies were the debtors and the creditors were the crown. All right, until under the colonial rule until it was replaced by the New Jersey Legislative Council under the New Jersey Constitution of 1776. All right. So you see the authority of the Provincial Council of New Jersey under King and Parliament was the crown. Okay, was the crown. The Provincial Council was established in 1702 upon the surrender of the property of East Jersey and those of West Jersey of the right of government to Queen Anne. Anne's government united the two colonies of New Jersey as under the Royal Charter, established a new system of government. Okay? This instruction from Queen Anne to Viscount Cornbury, the first royal governor of New Jersey, outlined a fusion of power system which overlapped executive and legislative judicial authority and provided for bicameral legislative consisting of council and a general assembly. Okay. On December 6, 1775, Governor William Franklin paroled New Jersey legislature until January 3rd, 1776, but it never met again. Why? Because it was met with, instead of the order of New Jersey Provincial Council, it was instead of it reconvening, i.e., going back from an interregnum to a calling a parliament. All right, it became synodine, as well as instead that an order was given by the new corrupt de facto New Jersey Provincial Congress for the arrest of William Franklin. All right. On July 2nd, 1776, Provincial Council approved a new constitution, and on August 13th, a new legislature was elected, which appointed Provincial Council, being succeeded by the elected New Jersey Legislative Council. So they put the crown in what they call the interregnum. An interregnum is when the transfer of the authority of the crown, or the power of the crown, or the prerogatives of the crown is in the demise. Okay? There's no one to sit in that office. This is what's being taken place. This is what was passed over to the colonies from the monarch called the House of Stewards. All right? They strict the prerogatives and priorities of the crown. All right? I'm going to show you. I'm going to show you. So everybody, please, I hope you got a good memory of what's being spoken to you today, because if you can't follow along, then you're going to lose sight very quick. All right. So now let's go into the YouTube video. Remember, the authority here governing New Jersey is the crown, and the crown is the authoritative power of England. Okay, of England. We already know allodial title is not in the United States. We know allodial title is in one ownership, and the only ownership that you can have, is, if it's not the monarch, it's the crown. Okay? That's why you have statutes of mortmain, dead pledge. The crown owns everything. The crown, which is personified or incarnated or incorporated as a natural person or corporation soul. And you see my credentials already, so I'm not going to go through them. I'm not going to worry about showing them now. All right, so let's go to the video. Everybody listen.
Filing your tax return is different on pretaxusa.com. First off, there are no extra fees for premium or self-employed taxes.
Real. I'm not real. I just manifest to come and tell you something every 26,000 years. And you'll find me in the history of banking, which I'm going to pull up shortly. So y'all just sit back, relax, and stop all this foolishness. There's no need for it. The fake pandemic happened, right? Because they know what's getting ready to happen to them. So as you can see.
Sorry about that, y'all.
I can share it on my screen. So that you can come up to your higher self. And the only way you're going to do that is through myself, and I'm talking about everybody right about now. You don't come into your and being selfish. Y'all got to get
it right.
I don't want to hear no more of anybody got any issues about Joshua or nobody else, because we beyond that now, y'all. You feel me?
Yes, ma'am.
All right. Now, where we're going first is
I'm trying to stretch the screen out. Hold on. Stop. Okay, here we go. Okay.
go here. The moment everybody been waiting for, so I'm a work my way backwards a little bit, and just go with the flow of things. Let's get with the allodial title first. If everybody wants, no, now look, I've been to bring my passport. I meant to scan my passport in so that I can share it on my screen. Bring my purse out of my room. While he's bringing my purse. Here's the allodial title that I hold. It's got the International Court of Justice Judge seal on it. As you can see, the certificate number. Okay, it dates back to May the 1st, 1540. It was issued to me on July the 19th, 2019. Shortly after that, the fake pandemic happened, right? Because they know what's getting ready to happen to them. So So as you can see, I could have put this in my name only, and walked away and being selfish. Y'all got to get rid of that ego and that selfishness. And the only way you're going to do that is that you see me demonstrate that. What you see mama do, the children do.
Stop.
So here is the...
Let's read right here, everybody. The allodial title hereof resolves all marketable titles and deeds, including bifurcated mortgages. In addition, certified sovereignty allows for allodial title issuing, making the individual lord and or lady sovereign, entitling unto their rightful singular birthright as a human being, enjoying the privileges, benefits of the land associated with the allodial title hereof, as disgraced by the sovereign himself. Blackstone's Commentary 247, Corpus Juris Secundum. All right. First of all, you could not use Blackstone's commentaries and his interpretation on land rights in lieu of what we call feudal tenures, because Native Americans were not back in the time of the Anglo-Saxon times when the conquest took place. All right. You could not claim such a right in lands. All right. Especially on an international level, because all treaty-made contracts, those were originally created by the original contracting clause, Article 1, Section 10, are null and void. Every single one of them. All right? You must understand that. All right? We know that all the states, then called colonies, were made part of the Union of the Articles of Confederation when the Crown, i.e. the Provincial Council, i.e. New Jersey, was still in place. All right? The Crown was still in place. Why? Because the Stuarts stripped the power of the Crown. Yes, they stripped the power of the Crown. All right? Who was the last queen sitting on the crown of what we call Great Britain? Queen Anne. They didn't have the right to devise property. That's not their right. The status of a woman here in North America was based upon the status of our two secretary via trim. Frederick Douglass understood that. The state of his mother was. And all those who took on the birthright descendancy after the mother based off matrilineal descent and not patrilineal descent. It's very important to understand that. She's quoting Blackstone's commentary. I got the whole volume right here. Just listen.
Allodial title. Let me roll it back a little bit so you can see. See that? Certificate of allodial title. That trumps anything that anybody has done in the United States and its entities and whatever else on the land operating along. Okay? I put it into the holder and the beneficiaries is the people. Of the Shawnee Cherokee Nation Pure Trust Foundation as the recorder of the First Republic Registered Foundation, which I will share shortly. And I'm going to read the allodial title for the record tonight. Y'all ready? Here we go.
Ma'am, let's go. Go.
For the record, the allodial title hereof resolves all marketable titles and deeds, including bifurcated mortgages. In addition, certified sovereignty allows the allodial title issuance, making the individual lord and or lady sovereign, entitling unto their rightful singular birthright as a human being, enjoying the privilege, benefits of the land associated with the allodial title hereof, as of the grace by the sovereign himself. 1 Blackstone's Commentaries 242, Corpus Juris Support them.
Stop. Okay. So we understand that Blackstone's commentary in regards to privileges, benefits of the land associated with allodial land given to lords. All right. We know lordship is a term associated with those who are allowed to have estates and land by their deeds or their charters given to them by the minor. Okay. We know that when you look up the word man, man is a term in the Black Law Dictionary associated with serfs, what else? Those who were subject to what we call, what they call a status of servitude. All right. They're the ones who were bound to the master by way of contract law. Okay. Look it up in my last lecture I just did. I explained and showed you the definition of monster, lordship, and man under the Black Law Dictionary. Look those terms up. All right. When you go back to the Provincial Council, it was called the House of Lords. All right. They were called the House of Lords. A allodial title issued to make the individual and or lady sovereign entitled unto their rightful singular birthright as a human being enjoyed the privileged benefits of the land associated with the title, their title hereof. So we understand a allodial title is in the minor. And we know it passes by primogeniture, by birthright. So whatever the mother is saying, she's definitely wrong in her understanding. Okay? We're going to clear it up. Let's clear it up. Peter Tinger. If she's quoting Blackstone, that means that she knows something about English history. Once again, if she's quoting Blackstone, she knows something about English history because we know Blackstone wrote the commentaries on English history. All right? Yes, she wrote the commentaries on English history, going back to what we call time immemorial. And he has a whole chapter on corporations, and he knows about the crown, i.e., corporation soul, in his commentaries. All right? But you just can't cut and paste stuff from his commentaries and assume they're going to work for your benefit, because they're not, because it's only for the beneficiaries, the heirs, who have the right to the intel state. You can't transfer a sell of land to anybody other than to the heirs. The heirs. You can't do that. Okay. Feudal tenure and land from an English perspective. Under the English feudal system, several different forms of land tenures existed, each effectively a contract with different rights and duties attached thereto. Such tenures could be either freehold, signifying that they were hereditable or perpetual, or non-free, where the tenancy terminated on the tenant's death or at an earlier specific period. It's very important that you understand that. We're not talking about allodial land. We're talking about fee simple. All right? We're talking about fee simple. In England's ancient past, large parts of the rim were unoccupied and owned as allodial title. The landowner simply cooperated with the king out of mutual interest instead of legal obligation. It was not until the Norman Conquest, you got to go back to the Norman Conquest, when William the Conqueror declared himself to be the sole allodial owner of the entire rim, that the land tenure changed drastically. In William's kingdom, the common exchange and sale of land became restricted, and all landowners were made to buy the service of the Lord. This was called freeing common soakage. All right? Freeing common soakage. It was a tax. Let's review that real quick. Taxation. We know everybody who has in their possession a deed is subject to the encumbrances of the eminent domain power of the state, right? You got to pay your tax, whether it's real estate or whether it's land. You don't pay those taxes, they coming for it. Taxation in medieval England was a system of raising money for the royal and governmental expenses. During the Anglo-Saxon period, the main form of taxation was land taxes, although custom duties and fees for mint coin were also imposed. The most important tax of the late Anglo-Saxon period was the guild. All right, a land tax first regularly collected in 1012 to pay the mercenaries after the Norman conquest in England. Back to the Norman conquest. The guilds continued to be collected until 1162, but was eventually replaced with taxes on personal property and income. Okay, so let's work our way down. 597 to 1066. All right. Alfred the Great. All right, this is where it originated from. King Edward's son, Ethelred the Unready. All right. Edward the Confessor. I think I seen King Edgar in here too. Our Jesus Christ. When he in here? Right there. Our Jesus Christ. All right. It said our Jesus Christ developed the tax system further by periodically recalling and reminting all the coinage with the moneyers being forced to pay for new dies. All profits from these actually went to the king and were a royal right. Despite all these changes, the Anglo-Saxon Chronicles recorded payments of 132,000 in tribute to the Scandinavian taxes from 991 to 1012. All right. So the origin of the taxation system originated from the Middle Ages. All right. Where we were the original creditors. All right. It worked its way all the way up from Alfred the Great, King Edward the Peaceful, Ethelred the Unready, Edward the Confessor, and they're going to see Edward the First. All right. Henry the First. All right. William the Conqueror's son. Henry the Second. Son of Godfrey the Fifth Count of Anjou, where my family descend down from. Stefan, Saladin, Richard I, time immemorial. King John, the one who signed the Magna Carta, where the English rights were protected. Henry III, all right, to Edward I. All right, to Edward I, we find this origin of taxation. All right, make its way all the way up to the 13th, 14th, 15th, and on up to the 16th, 17th, 18th, 19th century. Okay, so there's a history of this record of taxation. But we were the ones being taxed. We were not the debtors. We were the creditors. All right? Yes, we were the creditors, not the debtors. All right? They switched plates with us. I'm going to prove it to you. Edward the First. Now we know Crown Land is Intel. Hold that door. I can't get my coffee right. All right. We all know what Crown Land is. And crown land is intel land. Intel land is not the same as fee and simple. Fee and simple is not the same as intel. From fee and simple, you got fee and defeasible, and from fee and defeasible, you got life estate for the life of the term. Once the life of that person runs out in lieu of their right of possession, it automatically escheats. Okay? Crown land, sometimes called crown land, also known as royal domains, is territory area belong to the monarch who personifies the crown, the corporation soul, the natural person. All right, it's equivalent of a entail. All right, an entail estate, fetail. In English common law, fetail or entail in Scottish law is a form of trust established by a deed or settlement that restricts the sale or inheritance of an estate and real property and prevents that property from being sold, devised by will, or otherwise alienated by the tenant in possession, instead cause it to pass automatically by operation of law to an heir determined by the settlement deed. All right? The term fetail and telesi are from medieval Latin, which means to cut short. Fetail deeds are in contrast to fee simple. All right? Once again, fetail deeds are in contrast to fee simple deeds. Possessors which have an unrestricted title to the property and are empowered to bequest or dispose of it as they wish, although it may be subject to the allodial title of the monarch or the government body with the power of eminent domain. So you got two: the allodial power of the monarch, or that of what they call the eminent domain power of what we call the state or the federal government. One of the two. All right. Very, very, very important that you understand that. We know the crown land is intel and is personified by the crown and cannot be separated. Okay? It's part of the public trust. Okay. Now that you understand that. Right here. Since New Jersey is the crown, right? I showed you. New Jersey is the provincial council was the crown. Whether there was a king sitting in office or not, it always and forever will remain the crown. And the office or the authority of the crown is perpetual. All right? Perpetual. Gifts, grants, conveyances by state are allodial. We know the state or the United States don't own no land allodial. It just said it. Their highest form is fee and simple. They got to pay taxes. They got to raise taxes. Taxes is a result of free and common soakers. Let me just prove it. Let me just type it out. Soakage. Soakage was one of the feudal duties and land tenures formed an English feudal system. It eventually evolved into the freehold tenure called free and common soakage. All right? Which did not involve feudal duties. Farmers held land in exchange for a clearly defined fixed payments made at specific intervals to the feudal lord. In turn, the lord was obligated to provide certain services such as protection, to the farmers and other duties to the crown. Payment usually took the form of cash, or occasionally could be made with goods. The English statute of Queen Imperatrix of Edward I, there go that king again, established the succus tenure path from one generation or nominee to the next would be subject to inquisition post-mortem, which would usually involve feudal relief taxes. This contrasts to treatment of leases, which could be lifelong and readily subject to forfeiture and rent increase. Okay? Rent increases. And there we go, Blackstone right here. The etymology of soccus, according to Blackstone, Latin was the word for plow. Okay? Blackstone said the word for soccus was plow. All right? So I hope you understand that, Sister what's her name? Miss Queen Redbird or Whitebird. Partner, don't mean to confuse the name, but you know, you have your concepts is very wrong. Okay. Let's go here. This is legislative statute or parliamentary statute. You can see it either way. Gift grants conveyances by state allodial. All gift grants or conveyances made prior to and after July 4th, 1776 of an estate of inheritance. You hear that? An estate of inheritance by a letter patent, i.e. a charter, under the great seal of the state of New Jersey, or any other manner by the statute. That goes for any other state within the state of the Union or any other territory that was ceded to the United States by way of secession. All right? 1 second. By way of secession. All right? So it says all gifts, grants, or conveyances made prior to and after July 4th, 1776 of an estate of inheritance by letter patent under the great seal of this state or any other manner by this state, by the legislators thereof, or by the commissioners or agents of forfeited estates, or by other lawful and competent authority under this state, shall be and remain allodial, and not feudal, and shall forever be and continue in free pure allodium only. Forever discharged of all feudal tenures and the incidents thereof and all other services whatsoever. So feudal tenures, land ownership is abolished. All right? It's abolished. Y'all better pay attention to what's being said. Let's qualify it. We already know what feudal land tenure is, right? Let's just go there again so you don't say you didn't know. On the English feudal system, so if it started with us, it's going to end with us, okay? All land tenures were established under the feudal tenure land law given by way of what we call William the Conqueror, because prior to that, the land wasn't broken down and divided in what we call tenures, all right? It happened when William the Conqueror invaded England, all right? That's when it happened. Prior to that, it was one allodial land, all belonging to the monarch and his kindred, his heirs, his successors, all right? So as it was in the beginning, should be in the end. Why? Because it just said, all English feudal tenure will be what? Abolished. And it ain't starting with the back in the Middle Ages day. It said in 1776. So it forgot all the way about the Dark Ages and brought us up to the year 1776, that all feudal tenures going back to the time of William the Conqueror are abolished, and that the English people can now live free, clear, because now the land is allodial under the king. I was the first person to establish you as English heir to successor. No one has done that. All right? No one has done that. So everything that was invaded, taken, conquest, discovered by prescription or acquisition by way of the eminent domain power of the state, because we know that the state, according to the statute, is allodial. But I'm going to show you that they don't practice allodial title. They practice fee and simple, like the United States practice fee and simple. Thus, you pay free and common soakage, as the statute's about to say now. Let's see. This is not me. This is my law. I didn't come to change the law. I come to fulfill the law. This is prophecy. Certain tenures and holdings turn into free and common soakage. All feudal tenures of honors, manors, lands, tenements, or hereditaments, or estates of inheritance at the common law, held either of the King of England or of any other person sitting in the position of a king, establishing the body of politics, being the king and parliament, i.e. king and legislator, at any time before July 4th, 1776, because that's when all feudal tenures are abolished and comes back under allodial ownership of the crown, i.e. the monarch, i.e. the king, i.e. the English throne. And this was passed July 4th, 1776. It didn't go back to the time of William the Conqueror. It started here in July 4th, 1776, and declared it by Section 3 in the Act entitled An Act Concerning Tenures, passed February 18th, 1795, qualified it to be turned into holding and free and common soakage from the time of their creation and forever thereafter should continue to be free and held of common soakage, discharge of all tenures, charges, and instances enumerated in the said Section 3. Did you hear that, y'all? No, y'all didn't hear me. Let's see. I'm showing you the legislation. What is common recovery? We talk about this all the time. Common recovery was a legal proceeding in England that enabled lawyers to convert an entail estate, i.e. the crown states, to what we call fee and simple estates, and into what we call absolute ownership, whether it's fee simple, fee indeterminable, or life estates. All right, I'm gonna show you proof. They changed our estate as heirs into fee simple estate where you can sell it to anybody. All right. This was accomplished through the use of series of collusive legal procedures by way of a legal fiction or corporate fiction or corporation, i.e. a legal person and not natural people. All right. Some parts of which were fictional and others unenforceable and therefore null and void. It was devised and perfected by lawyers in the second half of the 15th century. A 1472 case known as the Taxation case increased its popularity. Okay. You must understand what's going on. Entail were originally designed to keep ownership of land within a family. Thanks to the effect of statutes, the donors conditional above. Who passed that statute? Edward I of the Plantagenet the Crown, my family's house. Godfrey, the fifth Count of Anjou, his great-great-grandfather. All right? Come on, y'all. Let's go here. From after June 12th, 1795, 1795, all right? No fine or common recovery that has been or shall be entered, may or suffer in any court or record of the state shall operate or be construed to be a conveyance or assurance of real estate or any way bar a issue in entail or feetail. Why? Because the heirs are back. All right? Or reversion and remandment of their lawful claims to entries and uses custom to the contrary, anywise as notwithstanding. So any person holding a fee simple deed is not going to hold up in the court of law. It's not going to hold up. If you got a fee simple deed and you're heir, then you're good. But if you're not an heir, then you're not. Why? Let's see why. I'm good. New Jersey Revised Statute, Title 46(3):12. A warranty made by a tenant for life or real estate shall be inoperative and void against all persons to whom such real estate should descend or come in reversion or remandment. Okay? So if you got a life estate, fee terminable estate, fee simple estate, it's not going to hold up like it's been. It's not going to hold a can or wait. Let me show you a case law to qualify that. I'm good. Bear with me. Let me just find it. Not that one. Not Marshall. Not this one. I thought I saved it. Give me 1 second. I can pull it up though for you. I tell you that. Where will we at? Warranty. We're talking about warranting life. Warranties by life tenant voids as reversion remainder. Let me give you a case law to support this. Mm-hmm. Newland versus Freeman. Check this out, y'all. Oh, I can find it. This is all based upon dealing with a will, a last will and testament. Right here. Listen to what's being said, y'all. As to the personal property, the court was of the opinion that Richard Freeman, having given to said Sarah the power to dispose of the personal estate to which he would otherwise have been entitled by the marriage, was borrowed by the marriage article, that it was according to the court to admit the paper writing to probate as the foundation of further proceeding in equity, it was thereupon considered by the court that the paper writing being admitted to probate as the last will and testament of Sarah Freeman disposed upon the personal estate therein mentioned, and that the same be so certified. This was based upon a will that was created, and the person who wrote it was illiterate. Let's just go back to that real quick, just give you a syllabus of the case. Check it out. It says here, the probate of a will of land by a married woman cannot be had in a county court. All right. A married woman can only be made an appointment in the nature of a will of real estate under a power of appointment specially given in some deed, and that appointment of the courts of equity have alone the jurisdiction to determine on and enforce. But a married woman, by her husband's consent, can make a will of personal property, and where he was covenanted in a marriage settlement that she may make such will, but without his consent from the particulars will she make this is still her will as the personal property, sufficient at least to repel his right of administering and to authorize the granting of administration to her appointee with the will annex. All right, so a will was created, a testamentary was created, a last will and testament was created. Let's go back down here. Let's see what the court say about the person who made the will. This is giving you a background of the case. All right. As to the real property, the court was of the opinion that famous cover, being accepted in the statute of Henry VIII, had no power to devise real estate, and that the heirs at law, not being parties, were of course not affected by the marriage article. It was therefore considered that the paper writing, so far as it disposed of real estate, should not be admitted to probate as the last will and testament of Sarah Freeman, disposed of real estate therein mentioned, and that the same be so certified by the court. But is that it? Court. But the judgment as to the personal estate and the refusal of the motion for a new trial, the caveator being dissatisfied, prayed an appeal to the Supreme Court from the other part of the judgment of the plaintiff's appeal. Let's go to one where I want to go to. We are of an opinion that none of the exceptions urged by either of the parties to the judgment below can be sustained, and that the law has been fairly expounded and correctly administered upon the trial. The instrument upon which the issue was made upon could not be found a will of lands, because the supposed testatrix was a married woman, and therefore in law incapable of devising land. You hear that? A woman couldn't devise land. She couldn't separate land, all right? And therefore, in law, incapable of devising land. By the common law of England, you should have known this, after the Norman conquest, lands could not be devised. By the statutes of Williams and Henry VIII, explained because of the abundant caution enacted that all persons seized in fee simple. Did you hear that? All persons seized in fee simple, except females, converse, infants, idiots, and persons of non-sane memory, might devise to any other person except body corporate. You hear that? Except body corporate, 2/3 of their land held in chivalry, and the whole of those holding in soakage. This was a law brought over to this country by our ancestors, and as all things here before the revolution whereby free and common soakers. This power was divided and applied to all lands within the colony. Did y'all hear that? Did y'all hear that? I'll read it again. It stated that because of the abundant caution enacted that all persons seized in fee simple. You got intel and you got fee simple. Intel is for heirs, fee simple is for anybody. Okay? Fees tells for heirs, because we know heirs are those who are heirs to the crown, because the crown land is intel. And when the land is ceded because there are no heirs, then it automatically is streets to the crown. So the only person who can gain back the estate is the king. All right? This was the law brought over by the country by our ancestors, and all tenants here before the revolution were by free and common soakers. All right? Did you hear that? Let's go here. All right. So it said, oh yeah, I know where I want to go. Hold on. Let me see if I can find it. Yeah. All right, let's move forward. All right, let's see. Let's go back here. So it said a warranty made by a tenant for life of real estate shall be inoperative and void against all persons to whom such real estate should descend or come to reversion or remand. Now we know that all, and it just said right here in this case that all persons seize. Can it just say that? It says all persons seize. Let's go back there. Right here. Everybody pay close attention to this. It was enacted that all persons seized in fee and simple, except feminists, converts, infants, idiots, and persons of non-sane memory, might divide to any other person except body corporate 2/3 of their land held in chivalry and the whole of the holding and soakers, because that was the practice and which of all tenures here before the revolution, that they paid free and common soakers. It says this in Marbury versus Madison as well. Okay, so why is this important? We go back to judgment by statute. New Jersey by statute is states and tells abolished. All right, we know estates and tell is fee tell, which means it's inheritable. It belongs to heirs. It says here, just like it said in the case, whenever any conveyance, will, or instrument in writing shall here have to be made, whereby any grantee, devisee, or other person should become seized in law. So you're talking about seizing persons. All right? Seizing your persons. Let me see if I can find this. Fee tail Cornwall. They ain't hiding this, y'all. Listen to this. Watch this, y'all. Look how blind we are to the truth. All right. Common recovery through a legal fiction. All right. They changed fee-tail estates until free and simple estates. All right. By way of lawyers doing this. All right. Lawyers are doing this. That's why when you go to court, you need an attorney to represent yourself because you're incompetent. A fee-tail is a common law interest in land, which is now abolished in most states. You just read it, abolished in New Jersey state statute. All right. The owner of the land in fee-tail is required to pass that land on to their children, who then may be required to pass it to their children. A fee-tail is created when a deed uses the word the heirs of his body, as in John Doe and the heirs of his body. We ain't talking about some stuff you created, because how did you create something without having it in your possession from you will be the creator. All right, you can't give nothing that you don't own, or give something that's not in your possession from the original origin of the ownership. All right, or the grantor, or deviser, the devisee. All right, yeah, divisor. It says, due to the modern belief that fee-tails are overly burdensome and inefficient, most jurisdictions in the United States abolish the fee-tail, and this language in a deed instead create fee simple. Did you hear that? Due to the modern belief that fee-tails are overly burdensome and inefficient, most jurisdictions in the United States abolish the fee-tail, and this language is indeed instead created fee and simple. Additionally, many states have adopted disentailing statutes, which in turn already exist. Disentail a statute which turn already. Let me read that again. Additionally, many states have adopted disentailing statutes which turn already existing fee-tail interest into interest owned and fee simple. Did y'all hear that? For example, Alabama law prohibits the creation of a new fee-tail and turns all existing fee-tails into fee simple. Once they are transferred into fee simple, it states with a statute like this one, a party can turn their fee-tail into a fee simple through the use of a straw man transaction. Did y'all hear that? All right. These are straight, concrete facts that I'm giving you. All right. Indisputable facts that I'm giving you. How I know it? They changed fee simple, changed entail estates into fee and simple, right? Because we know entail estates are subject to allodial estates when they're under the authority of what we call the minor, called the crown. All right. But we know that the United States or the states, the highest form of ownership is fee simple, and fee simple is a result of common recovery, which, as according to the statute, is not going to work for you anymore. All right. Let's prove it. Y'all see this? Hold on. Come on. Bear with me. Okay. There's your handsome king. All right. Let's move forward. There's your cartoon character, your king. right. The Essentials of New Jersey Real Estate, 12th edition. All right. All you real estate agents, all those who they claim they know about ownership of property, I'm about to prove you wrong. All right. Let's see how much you know. All right. Remembering legal terminology, you must remember. Throughout this chapter and the rest of the book, we will refer to people as grantors and grantee, trusters or trustee, mortgager or mortgagee, and so on. Because the terminology can be confusing, we've included this table to help you remember who's who in the transaction, i.e., the creditor, the borrower, the creditor, the debtor, the lender, the borrower. Which one are you? All right. So we have the divisor, the grantor, legator, lessor, mortgager, offerer, optioner, sublessor, sublessor, or truster. These are the positions of a creditor. All right. Person giving the product. All right. The person selling the product. Person receiving the product is the borrower. All right. I.e., the debtor. He's called the devisee, the grantee, the legatee, lessee, mortgagee, offeree, optionee, subleasee, or trustee. All right, you hear that? Did you see that? Let's go back to the statute. Whenever any conveyance, will, or instrument in writing shall have to be made, whereby any grantee, devisee, or other person should become seized in law or in equity of such estate in real estate as under the statute of 13th of Edward I, called the Statutes of Entail, would have been held in estate in fee tail of any type of character. Now such conveyances, will, or instrument shall vest in the state in fee simple in such grantee, devisee, or other persons. Did y'all hear that? Did y'all hear that? There go your stolen birthright of the English heir successors who are descendants of Edward the First. Edward the First. Why? Let me show you. Queen of Petoris. From and after March 18th, 1795, any freeholder who may give, sell, or alienate the real estate whereof he is, or at any time shall be seized in fee and simple or part thereof at his pleasure, and such donee, purchase, or alienee shall hold the same free of anything or services to the donor or seller or aliener. So now they're going contrary what Queen Imperatrice actually established by Edward I. Why? Because they have abolished entail estates. They have abolished it, y'all, through common recovery. Through common recovery, y'all. So let's go back here. So you got to ask yourself, which position do you play? As the English heirs and successors, we all fit this description. We are creditors. If we're heirs of the crown, we are creditors. How do I know that? Let's see. Content versus Dalton. At the common law, a dividing to one in the heirs of his body or his lawful issue creates an estate in fetail, but by the statute of descent, such an estate is converted into a life estate, and the one which vested remainder in fee in his children. All right, so this is what's going on. Based off what I just proven by the statute of abolish of entail estate, i.e. fetail estate. They have created fee simple by way of statutes. All right? By way of statutes. The various contentions necessitates first the determination of the estate vested in Rosamond and Mary Ella under the will. Second, the character of the possession required under the statute for the vesting of a title and one other than the true owner. You hear that? And third, whether the complainant in possession is effective to vest complete title in him as against the answering defendants. All right? That's the subject of the case. In construing the Dalton's will, it should be borne in mind that, as in evident from its composition, it was prepared by one unskilled in legal phraseology, unlearned in the law, and ignorant of the rules of punctuation as well as those of English grammar. Everything is based off English understanding of what we call English land law, and probably was prepared by a testator himself, certainly not by a lawyer. Careful reading of the sixth paragraph above quoted shows that it's readily divisible into four parts as follows. We're not going to go into the full part, but I'm going to read something in regards to the status of the will that was created based off the woman devising the estate that was left to her. It is conceded by counsel for both complainants and the answering defendants that common law language of Part 1 above quoted will vest a fetail in Rosamond and Mary Ella, and that by the statute of descent, such estate is changed to a life estate, and the daughters with a vested remainder and fee to their children. Complainant contends, however, that the subsequent language of the paragraph vests remainder and fee to Leon Dalton. All right, so this is an argument who has the right of reversion. All right, let's go here. We see here, as the ancient maxim has it, he who gives nothing, he who gives nothing, who has nothing. Pardon me, read this again. As the ancient maxim has it, he gives nothing who has nothing, or no one gives who possess not. Where a life tenant conveys a warrant, a fee, his warranty is void. Did you hear that? Where a life tenant conveys a warrant and fee, his warranty is void. So all those who hold fee simple estates, it is void for want of remandering and reverting of the estate to the true and rightful owner of that property. Okay? Let's get another qualification. I think this is okay. We just read that, Neville versus what was that? Neville versus Friedman. That was the case I was looking for. Let's go here. This is another case. This is Dalton versus Staten. By the common law of England, after the conquest, lands could not be divided by the statutes of wills, explained because abundant caution enacted that all persons seized and fee simple, except femmes, converts, infants, idiots, and persons of non-sane memory, might divide to any other person except bodies corporate. So you must, the reason why they didn't want us to form a body corporate, because under 46:3-2, under free and common focus, when I incorporate as the crown, i.e. the king, that all the royal prerogatives came back through our certificate of incorporation, i.e. our charter. All right? All those rights were sitting in dormant, waiting for me to come back and pick up that sword and start swinging. All right? This is another case. Let's find another one. It says here, this is United States versus Huron. Where an act of parliament is made for the public good, as for the advancement of religion and justice, or to prevent injury and wrong, the king is bound by such act, though not particularly named therein. But where a statute is general, and thereby any prerogative, right, title, or interest is divested or taken from the king, in such case the king is not bound unless the statute is made to extend to him by express word. Acts of Parliament, says Chitty, which would divest or abridge the king of his prerogative, his interest, or his remedies in the slightest degree, do not in general extend to or bind the king unless thereby expressed by words of that effect. Therefore, says the same learned author, the statutes of limitations, bankruptcy, and solvency set up are irrelevant in the case of the king, nor does the statute of frauds relate to him, which last proposition is doubted by high authority. Exceptions exist to the rule undoubtedly, as where the statute is passed for the general advancement of learning, morality, and the justice, or to prevent fraud, injury, and wrong, or where an act of the parliament gives a new estate or right to the king, as in the case that will bind him as the matter enjoying or using the estate or right as well as the subject. Debts due to the United States is expressly provided shall be entitled to preference or priority over all claims except the claim for fees, costs, and expenses of suits and other proceedings under the Bankruptcy Act for the custody of the bankruptcy property. Let's find some more. We'll have some more. Right here. Text writers also of the highest authority have uniformly promulgated the same rule. Speaking of the order of discharge, Deacon says, it does not release the bankrupt from a debt due to the crown. For as the crown is not bound by any statute unless specifically named, the crown debts not being mentioned among those of the creditors in general, and any part of the statute relating to the proof of debt or of certificate of discharge, the crown, of course, will not be barred of the peculiar privileges it possesses for the recovery of its own debts. Nor does the Bankrupt Act impair or supersede the law for the collection of taxes, and that the rule also is found upon the same canon of construction, to wit, that the crown is not bound by the bankrupt law, and therefore says for the appointment of assignees does not relate to the act of bankruptcy as against that of the crown process. Of the crown process, but the bankrupt personal property is bound under an extent event when tested subsequently to the appointment of the assignees, to which he adds that bankrupt certificate is no discharge as against the crown. Did everybody hear that? As against the crown. Such certificate, said Robinson, will not release the bankrupt from a debt or liability incurred by means of any fraud, nor from the debt due to the crown, nor from debts which bankrupt stands charged at the suit of the crown. You hear that? Or of any person for any offense against a statute relating to any breach of the public revenue, or as such of the sheriff or officer, public officer, or any bail bonds entered into for the appearance of any person prosecuted for any such offense. He says the crown is not bound by the acts relating to bankrupts not being named in them. Therefore, an extent served upon the property of the bankrupt will bind it from the testing of the writ until the actual assignment of the commissioner. But the king is bound by the actual assignment because the property is then absolutely transferred to the third person. All right? You must understand what's going on. It is the maxim of the common law that when an act of parliament is passed for the public good, you just read the statutes. All right? Common recovery would not prevent an entailed state in lieu of the reversion or management of that estate to the rightful owners, i.e. the English people. All right? I'm going to prove it to you. As for the advancement, religion, and justice, or to prevent injury or wrong, the king shall be bound by such acts, though not named, but when a statute in general and any prerogative, right, title, or interest would be divested or taken from the king. In such a case, he should not be bound unless the statutes made by the express words to extend to him, for which he cites both English and American authorities, and asks that the people of the state, being sovereign, have succeeded to the rights of the former sovereign, and that the people of the state are not bound by the general words and the insolvent law. Okay, let's find another one. United States Supreme Court. United States versus the State Bank of North Carolina. The right of priority of payments of debts due to the government is a prerogative of the Crown of England. Well known to the common law, it is founded not so much upon any personal advantage to the sovereign as upon motive of public policy to secure an adequate revenue to sustain the public burden and discharge the public debt, i.e., your debt. The claim of the United States to priority does not stand upon any sovereign prerogative. You hear that? But it's exclusively founded on the actual provision of our own statutes. The same policy which governed in the cases of royal prerogatives may be clearly traced in their statutes, and as that policy has mainly a reference to the public good, there is no reason for giving to them a straight or narrow interpretation. Like all other statutes of this nature, they ought to receive a fair and reasonable interpretation according to the just import of their terms. All right? The priority of the payment out of the estate of insolvent in favor of the United States was under the statutes of the United States, first applied to bonds for the payment of duties and to persons engaged in commerce. Did you hear that? Persons engaged in commerce. If you're engaged in commerce, then that's contract. And if you're not in English, then it's conscionable. If you are English, then the contracts that you're engaging in are unconscionable. All right? They are unconscionable. Let's find another source. United States Supreme Court, Marshall versus New York, 1920 case. At common law, the Crown of Great Britain, by virtue of a prerogative right, had priority over all subjects for the payment out of debts, property, of all debts due to it, whether the property was in the possession of a debtor or of a third person or a custodial legis, which means the custody of the law, and that the priority could be defeated or postponed only through the passing of the title to such property, transferring from entail to fee simple. Y'all see what I'm trying to tell y'all? Taking it from entail to fee simple by way of the statutory incorporation of the laws to strengthen the rights of those who are heirs of the entail estate that was subject to what we call crown land, the crown. Okay, and that the priority could be defeated or postponed only through passing title to such property absolutely by way of a lien before the sovereign sought to enforce his rights. Okay? Before the sovereign sought to enforce his right. I'm enforcing them now, though. The question whether the priority is a prerogative right or a rule of administration is a question of local law, the determination of which the highest court of the state concludes the federal law. So you shouldn't be going over to those international courts to deal with affairs home. All right? You shouldn't be going there. The priority extends to all property of the debtor within the borders of the state, whether the debtor be a resident or a non-resident, and is enforceable against such property in the hands of a receiver appointed by the federal court within the state. Since such a receiver takes property subject to all liens, properties, or privileges existing or accruing under the state law. All right? So all property owned by the state is due to state law. All property owned by the crown is due what? The crown prerogative. Okay? What else we got here? This is Aetna Casualty and Surety Company versus Broadmail. All right? District Court of Oregon. It is settled by the Supreme Court that the question whether this priority right is a prerogative right or a rule of administration is one of the local laws, and that determination thereof by the highest court of the state concludes the federal court, as Marshall in York said. We just read that. So that the court is bound by the doctrine promulgated by the Oregon case cited. It is hardly essential to define prerogatives with technical accuracy under Mr. Blackstone's definition. So I have the right to use Blackstone's definition. Why? Because Blackstone is interpreting English law, not that law that deals with Native American Indians. So you're using information that does not apply to you, which makes it abstract. It can only be applied to those rights and capacities which the king enjoys alone, in contradiction to others, and not to those which he enjoys in common with any of his subjects. A New Jersey chancellor has defined royal prerogative. New Jersey, as that special preeminences which a sovereign has over all persons out of the course of the common law, by right of original dignity. In Great Britain, the royal prerogative includes the right of sending, receiving ambassadors, of making treaties, and theoretically of making wars and concluding peace, of summoning parliament, and or refusing assent to a bill, with many other political, judicial, ecclesiastical, etc. privileges. Such ridiculously prerogative, the word simply means a power of will, which is discretionary and above and uncontrolled by any other will. It is frequently used to express an uncontrolled will of a sovereign power in the state. It is applied not only to the king, but also to the legislative, judicial branches of the government. This kingly power or authority or privilege, whatsoever its scope or whatsoever its tribute, there is in it a sovereignty rests with the people and its country. Okay? The Supreme Court has declared that the right and priority of payment of debts due to the government is a prerogative of the crown. Well known to the common law, it is founded not so much upon the personal advantage to the sovereign as upon motives of public policy, in order to secure an adequate revenue to sustain the public burden and discharge the public debt. The claim of the United States, however, does not stand upon any sovereign prerogative, but is exclusively founded upon the actual provisions of their own statutes. Okay? The same policy which governs in the case of the royal prerogatives may be clearly traced in these statutes, and as that policy has mainly a reference to the public good, there is no reason for giving them the strict, narrow interpretation. United States versus Bank of North Carolina. We just read that. Okay? We got one more here. This is Chisholm versus Georgia. My favorite case. Matter of fact, I'm not going to read that. We ran through that case already. But that really shines a light on what is about to be shown to you in regards to debtors and creditors. Okay. So we understand the two categories. We know that the true owner, the allodial owner of the land, is the crown. And everything that the crown gives is by way of what we call a grant. All right. He's the creditor. He's the lender. All right. So we are as a successor, then we ain't in the same status as a debtor based off the concept of how the United States perceive it. All right. Because they don't deal with intel estates. They deal with fee simple estates. How we know it? Let's qualify that. Our points up for Berkeley. So as you can see, oh, come on. I'm sorry, I got to close out. Okay. Let me make sure y'all see this. This is the real estate book I showed you. All right. The highest form of ownership in North America is fee simple, fee determinable, and life estates. All right. Once again, you can go to any real estate book. You will not see entail in it. You'll see fee simple estates, fee determinable, and life estates. And we know that's all a result of what we call common recovery. All right. And estates and land. Everybody see that? States and land, chapter 6. I've been all through this book. Freehold, highest form. Highest form of freehold is fee simple, fee terminable, and fee in life estates. Don't say nothing about intel or allodial. Okay? Don't say nothing about it. There's a problem with that. Let's see why. The titles that you have are abstract titles given from your attorney. All right? They're abstract titles given from your attorney, so that means they're indefeasible. That's why you have to acquire title insurance. You have to acquire title insurance, all right? This becomes your certificate of title. It's the deed that's acquired by way of a instrument showing conveyance of real estate, which is abstract. Why? Let's see. Right here. Make sure you guys see this. Evidence of title. When dealing with owners of real estate, a purchaser or lender requires satisfactory proof that the seller is the owner and has a good title to the property. The documentary proof is called evidence of title. There are 4 generally used forms of title in evidence. Abstract of a title of attorney opinions, not concrete, not indefeasible. Title insurance, torrent certificate, and certificate of title. Why? Because the deed is not proof of a title. It proves the grantor transfers the property, but does not prove the grantor has a clear title. It does not prove that. You have a clear title. All right? Let's see why. Transfer of title. Title can be transferred 2 ways, voluntarily and involuntarily. Once again, voluntary or involuntary. Alienation voluntary is due a gift, grant, etc., sale or exchange. Involuntary is due what we call escheatment. When a person interstate and leaves no heirs, the title to his estate passes to the state. Okay? Involuntary. That brings me here. The power of prescription of sovereignty, acquisition of sovereignty. All right? This is called prescription of sovereignty or acquisition of sovereignty through what we call prescription of easement. All right? Prescription of easement through what they call the laws of discovery, which actually descended down from the laws of what we call conquest. We talked about that today. All right? Let's go to the diagram. Very simple. Look at this. Make sure y'all see this. Transfer of this deceased person's property. Every state has a law known as statute of descent and distribution. When a person dies interstate without leaving a will, the descendant real estate and personal property passes to his heirs according to that statute. Okay? Very important to understand that. Very important to understand that. All right? And let's see here. Let's qualify this. Let's go to this map. Get a good diagram of it. Everybody see this? So what happens? When the English heirs died, right? That means that all the property became escheated. All right? It was abandoned. All right? And we're talking about not the state of New Jersey, but all the states within the Union, as well as all the that were seceded to the United States. All right? All the territory. The Treaty of Paris, 1763, the Treaty of Northwest Ordinance, 1787, as well as the Treaty of Paris, 1783, all the territory that belonged to the crown actually belong to the crown, automatically transfer or pass to the colorable sovereignty of what we call the United States through acquisition of sovereignty. All right. We already see that the state of New Jersey was acting under the crown, right, called the Provincial Council. But the crown representatives were arrested and they took over and instituted what they call a de facto government, now called the incorporated state of New Jersey, the state of. All right. Once they incorporated, every of the property belonged to the heirs is ceded to the colonists, who were called the 13 colonies. All right. And they needed land, right? So when they took the land away by force, they had to compensate us. But they didn't compensate us because who they compensated was those who were not us. All right. We still have not been compensated for our right in the land, because you can't compensate us for something that you don't have. You can't pay a debt with paper currency. All right. So as a result of that, the eminent domain power of the state took over. All right. Took over. All right. And all the land and all the power and all the authority fell under the power of the governmental agencies. Because when the state and the United States represent claims, whether they're contracts, criminal, civil, it's in the name of the United States or in the name of the states, but it's represented by its agents. All right. And usually when there's an action in court in regards to action of trespass, it winds up in what we call non-payment of debt, i.e. taxes, i.e. encumbrances, i.e. priorities, i.e. prerogatives, such as in the crown. And with all things, it results in what we call a foreclosure. All right? Foreclosure. Now you got a sheriff's sale. Now you got adverse possession, and adverse possession is a result of what we call prescription of easement. A right and property that you do not own. Okay? And right and property that you do not own. What you have in your possession is one of these. It's either this one, a warranty deed, or a bargain and sell deed. That's all you have. But as we know, as it's stated, a deed is not proof of a title. It proves the grantor transferred it, right? But has that shown, but it does not show that whoever transferred it had a clear chain of title. That brings you back to here. Who is the creditor? Who is the creditor? All right? If you don't know who the creditor is, then you're in a world of trouble. Okay? You're in a world of trouble. So in closing, make sure I covered everything. So in closing, crown land is entail, estate, that passes with the monarchy being inseparable from it. All right? So if you're not repping the crown, then you're not repping anything. Okay? If you're not repping the crown, you're not repping anything. And we are incorporated to rep the crown. All right? We are incorporated to rep the crown. We personify the crown. We speak for the crown when no one else would. So with that, I greeted you in peace, and I'm going to leave you in peace. May the crown rule forever. Peace.